If you filed an I-130 petition to sponsor your spouse, your parents, your children, or other family members, and you just heard that the processing rules have changed in 2026, and now you're terrified that your case is going to be delayed, denied, or thrown out completely, I need you to take a breath and stay with me. There is a lot of confusion right now about what has actually changed, who is affected, and what you need to do, and I'm here to give you the facts so you can stop panicking and start understanding what's really going on. My name is Georgia, and you're watching Legal Focus USA, where we cut through the noise and give you clear, fact-based immigration information without the rumors, without the clickbait, and without the fear. Let's talk about what has actually changed with I-130 processing in 2026, who is truly affected, and what you need to know to protect your family petition. First, let me be very clear about something. USCIS has made some procedural updates to how they process I-130 petitions in 2026, but this does not mean that family-based immigration is being shut down. This does not mean that all pending I-130 petitions are being canceled. And this does not mean that you can no longer sponsor your family members. What has changed are certain processing procedures, documentation requirements, and timelines, and I'm going to explain exactly what those changes are and how they might affect you. Let's start with the basics. The I-130 form, which is officially called the Petition for Alien Relative, is the form that U.S. citizens and lawful permanent residents use to sponsor certain family members for green cards. If you are a U.S. citizen, you can sponsor your spouse, your parents, your children, and your siblings. If you are a green card holder, you can sponsor your spouse and your unmarried children. The I-130 is the first step in the family-based immigration process. Once the I-130 is approved, your family member either applies for their green card immediately if a visa number is available, or they wait in line until a visa number becomes available based on their priority date. Now, what has changed in 2026? USCIS has implemented several updates to how they process I-130 petitions. These changes were announced in late 2025 and began rolling out in early 2026. Let me walk you through each change step by step so you understand exactly what's different. Change number 1. Updated evidence requirements. USCIS has clarified and in some cases expanded the types of evidence they want to see when you file an I-130 petition. This particularly affects spousal petitions. USCIS is now asking for more detailed proof of a bona fide marriage, which means they want to see clear evidence that your marriage is real and not just for immigration purposes. This includes things like joint bank account statements, joint lease or mortgage documents, photos together with family members, evidence of shared financial responsibilities, and affidavits from people who know you as a couple. If you filed your I-130 in the past with minimal documentation, USCIS may now issue a request for evidence asking you to submit more proof. This is not new for everyone. USCIS has always had the right to ask for additional evidence, but they are now being more systematic about it and asking for more upfront. Change number 2. Stricter scrutiny of relationship fraud. USCIS has announced that they are increasing efforts to detect fraudulent marriages and relationships. This means more cases are being referred for in-person interviews, even for immediate relative petitions that in the past might have been approved without an interview. If you are sponsoring a spouse, you should expect that you may be called for an interview at a USCIS office, and you should be prepared to answer detailed questions about your relationship, your daily life together, and your plans for the future. This change is meant to prevent fraud, but it also means longer processing times for legitimate cases because interviews take time to schedule and conduct. Change number 3, changes to concurrent filing. In the past, if you were a U.S. citizen sponsoring an immediate relative who was already in the United States, you could file the I-130 petition and the I-485 adjustment of status application at the same time. This is called concurrent filing, and it saves time because both forms are processed together. USCIS has not eliminated concurrent filing, but they have updated the procedures for how they handle these cases. In some situations, they are now processing the I-130 and I-485 separately, which can lead to longer overall processing times. They are also being more strict about requiring that the beneficiary maintain lawful status at the time of filing and throughout the process. Change number 4. Priority date retention policies. For family preference categories, which are categories that have annual limits and backlogs, USCIS has clarified the rules around priority date retention. Your priority date is the date that your I-130 petition was filed, and it determines your place in line for a visa number. In the past, if your I-130 was approved, and then you upgraded to a different category, such as when a petitioner becomes a U.S. citizen, there were some questions about whether you could keep your original priority date. USCIS has now issued clearer guidance on when priority dates can be retained and when they cannot. This is actually a helpful clarification, but it has caused confusion because people are interpreting it as a new restriction when it's really just a clarification of existing policy. Change number 5. Processing times and case reassignments. USCIS has reorganized how they assign I-130 cases to different service centers and field offices. Some cases are being transferred to different locations for processing, which can cause delays. USCIS says this is to balance workloads and improve efficiency. But in the short term, it means some people are seeing their cases moved to a different office and their processing times extended. If you check your case status online and you see that your case has been transferred, this does not mean there is a problem with your case. It is part of the new processing procedures. Change number 6. Increased use of requests for evidence and notices of intent to deny. USCIS is issuing more RFEs and NOIs for I-130 petitions, especially for cases where they have concerns about the evidence submitted or the eligibility of the petitioner or beneficiary. An RFE means USCIS needs more information before they can make a decision. An NOID means USCIS is planning to deny your case unless you can provide evidence to overcome their concerns. If you receive an RFE or NOID, you must respond within the deadline, usually 30 to 87 days, and you should strongly consider working with an immigration attorney to prepare your response. Now let's talk about what these changes do not mean. These changes do not mean that USCIS is trying to stop family-based immigration. These changes do not mean that all I-130 petitions will be denied. These changes do not mean that you can no longer sponsor your family members. And these changes do not mean that cases filed before 2026 are going to be thrown out or canceled. What these changes do mean is that USCIS is being more thorough in how they review I-130 petitions, and they are asking for more evidence to make sure that relationships are genuine and that petitioners and beneficiaries are eligible. This is going to lead to longer processing times for many people, and it means you need to be more careful about how you prepare and submit your I-130 petition. Let me address some of the rumors that are spreading. Rumor number 1. USCIS is automatically denying all I-130 petitions filed by people who have been married for less than 2 years. False. USCIS is not automatically denying petitions based on the length of the marriage. However, they are scrutinizing newer marriages more carefully to make sure they are genuine. If you have been married for a short time, you need to submit strong evidence that your relationship is real. This has always been the case, but USCIS is now being more systematic about it. Rumor number 2. If you filed your I-130 before 2026, you are not affected by the new rules. Not exactly. While the new rules primarily affect cases filed in 2026 and later, USCIS can apply some of the updated procedures to cases that are still pending from before 2026. For example, if your case is still being processed and USCIS decides they need more evidence under the new guidelines, they can issue an RFE even if you filed your petition in 2024 or 2025. However, USCIS has stated that they are not retroactively changing eligibility requirements. So if you were eligible when you filed, you should still be eligible now. Rumor number 3. Green card holders can no longer sponsor their spouses. False. Green card holders, also known as lawful permanent residents, can still sponsor their spouses and unmarried children. What has changed is that USCIS is being more thorough in verifying that the petitioner is maintaining their permanent resident status and that they meet all the requirements to be a sponsor. If you are a green card holder and you have been living outside the United States for extended periods, USCIS may question whether you have abandoned your permanent residency, and this could affect your ability to sponsor someone. Rumor number 4. USCIS is canceling all pending I-130 cases and making everyone refile. Absolutely false. USCIS is not canceling pending cases. If you have a case that is currently being processed, it will continue to be processed. However, if USCIS needs additional information, they will issue an RFE. You do not need to refile unless USCIS specifically tells you to. Rumor number 5. The changes only affect marriage-based petitions. Not true. While marriage-based petitions are seeing the biggest impact because of the increased scrutiny on relationship fraud, all I-130 categories are affected by the procedural changes, including petitions for parents, children, and siblings. However, the level of scrutiny varies depending on the relationship. Immediate relative categories like spouses, parents, and unmarried children under 21 of U.S. citizens are generally processed faster and with fewer issues than family preference categories. So who is actually affected by these changes? You are affected if you are planning to file an I-130 petition in 2026 or later because you need to be aware of the updated evidence requirements and prepare your petition accordingly. You are affected if you have a pending I-130 petition and you receive an RFE or no ED because you need to respond carefully and thoroughly. You are affected if you are sponsoring a spouse and your marriage is relatively new because you can expect more scrutiny and possibly an interview. You are affected if you are a green card holder sponsoring a family member and you have spent significant time outside the United States because USCIS may question your permanent resident status. You are affected if your case is being transferred to a different USCIS office because this may cause delays in processing. You are not affected if your I-130 has already been approved and your family member is waiting for a visa number to become available. The changes do not affect approved petitions. You are not affected if your family member has already received their green card. These changes only apply to pending and new I-130 petitions. You are not affected if you are applying for a visa through a process that does not involve an I-130, such as employment-based immigration or asylum. Now let's talk about what you should do. Step 1. If you are planning to file an I-130 petition, take your time and prepare it carefully. Do not rush to file without gathering all the necessary evidence. USCIS has published updated instructions for the I-130 form on their website at uscis.gov. Read the instructions carefully and make sure you understand what documents you need to submit. For marriage-based petitions, gather as much evidence as possible showing that your relationship is genuine. This includes joint financial documents, photos, correspondence, affidavits from friends and family, and any other evidence that shows you have a real life together. Step 2. If you have a pending I-130 petition, monitor your case status regularly on the USCIS website. You can check your case status by entering your receipt number at uscis.gov. If your case is transferred to a different office, don't panic. This is part of the new procedures. However, if you receive an RFE or NOID, you must respond before the deadline. These notices are serious, and failure to respond can result in your case being denied. If you receive an RFE or NOID, I strongly recommend working with an immigration attorney to prepare your response. Step 3. Be prepared for an interview. If you are sponsoring a spouse or certain other family members, USCIS may schedule you for an in-person interview. Make sure both you and your family member are prepared to answer questions about your relationship. Be honest, be consistent, and bring any additional evidence that supports your case. If you are nervous about the interview, consider doing a practice interview with an attorney or a trusted advisor. Step 4. Keep your address and contact information updated with USCIS. If you move or change your phone number or email, you must notify USCIS using Form AR11 or through your online account. If USCIS tries to contact you and cannot reach you, it can cause serious delays or even result in your case being closed. Step 5. If you are a green card holder and you are sponsoring a family member, make sure you are maintaining your permanent resident status. This means living in the United States as your primary residence and not spending extended periods abroad. If you have been outside the United States for more than 6 months, you may face questions about whether you have abandoned your residency. If you need to travel for extended periods, consider applying for a re-entry permit before you leave. Step 6. Stay informed about processing times. USCIS publishes estimated processing times for each form and each office on their website. Keep in mind that these are estimates, and actual processing times can vary. If your case is taking longer than the estimated time, you can submit an inquiry through the USCIS website or contact the USCIS Contact Center. Step 7. Do not rely on social media for legal advice. There is so much misinformation circulating right now about the I-130 changes. People are posting in Facebook groups, on TikTok, on WhatsApp, and they are giving advice based on rumors or their own personal experiences, which may not apply to your situation. Always verify information with official sources like the USCIS website, and if you have questions about your specific case, talk to a licensed immigration attorney. Step 8. If you are considering withdrawing your I-130 petition because you heard the rules have changed and you think you no longer qualify, do not make that decision without talking to an attorney first. Withdrawing a petition is a serious step, and once you withdraw, you cannot undo it. An attorney can review your case and tell you whether the new rules actually affect your eligibility. Now, I want to talk specifically to people who are sponsoring spouses. I know this is an incredibly stressful time. You love someone, you want to build a life with them in the United States, and now you feel like the government is assuming your marriage is fake unless you can prove otherwise. This is frustrating and hurtful, and I understand why you feel that way. Unfortunately, marriage fraud is a real problem, and USCIS has a responsibility to prevent it. That doesn't make it any easier for legitimate couples who are just trying to be together. If you are in a genuine relationship, you will get through this process. Yes, it may take longer than you hoped. Yes, you may need to provide more evidence than you expected. Yes, you may be called for an interview. But if your marriage is real, you should be able to demonstrate that to USCIS. Gather your evidence carefully, be honest in all your submissions, and be patient. The vast majority of legitimate I-130 petitions are approved, even with the new procedures. For people who are sponsoring parents, children, or siblings, the changes are less dramatic, but you should still be prepared for possible delays and for the possibility of receiving an RFE. Make sure you submit all required documents with your initial petition, including proof of your relationship, proof of your U.S. citizenship or permanent residency, and proof that you meet the financial requirements to be a sponsor. Let me point you to some official resources. The USCIS website at uscis.gov has the most current information about I-130 processing, including the updated form instructions, processing times, and policy guidance. If you have a pending case, you can check your status online using your receipt number. The USCIS Contact Center can be reached at 1-800-375-5283 if you have questions, though wait times can be long. For information about visa availability and priority dates, check the Visa Bulletin published monthly by the State Department at travel.state.gov. If you need legal help, you can find a licensed immigration attorney through the American Immigration Lawyers Association at ILA.org. Be very careful about who you hire to help you with your immigration case. There are many people who call themselves immigration consultants or notarios who are not licensed to practice law and who may give you bad advice or even commit fraud. Make sure you work with a licensed attorney or a Board of Immigration Appeals accredited representative. I want to emphasize that immigration rules and procedures do not change overnight. Even when USCIS implements new policies, they usually phase them in over time, and there is usually guidance and clarification available. You have rights, you have due process, and you have the ability to challenge unfair decisions. If your I-130 is denied and you believe the denial was wrong, you may be able to file a motion to reopen or reconsider, or you may be able to appeal the decision. An attorney can help you understand your options. I also want to say that I know how emotionally exhausting the immigration process is. You are separated from your loved ones, you are spending thousands of dollars on fees and legal help, you are living in uncertainty, and you are constantly worried about what might go wrong. This takes a toll on your mental health, your relationships, and your sense of security. It's okay to acknowledge that this is hard. You are not alone. There are millions of families going through the same thing. But do not let fear or frustration cause you to make bad decisions. Do not give up on your petition without exploring all your options. Do not believe everything you read on social media, and do not try to cut corners or submit false information because you think it will speed up the process. Honesty and thoroughness are always the best approach, even if it takes longer. So let's summarize what you need to know. USCIS has implemented procedural changes to I-130 processing in 2026, including updated evidence requirements, increased scrutiny of relationship fraud, changes to concurrent filing procedures, and case reassignments that may cause delays. These changes do not mean that family-based immigration is being shut down or that all I-130 petitions will be denied. They mean that USCIS is being more thorough in how they review cases, and you need to be prepared to provide strong evidence that your family relationship is genuine and that you meet all eligibility requirements. If you are filing a new I-130, take your time and prepare your petition carefully. If you have a pending case, monitor your status and respond promptly to any requests from USCIS. If you are sponsoring a spouse, expect increased scrutiny and possibly an interview. Always verify information with official sources and seek help from a licensed attorney if you have questions about your specific case. Remember, immigration rules are complex, but they are not designed to trap you or to separate families. The system is slow and frustrating, but it is not impossible. Thousands of families successfully navigate the I-130 process every year, and with the right preparation and guidance, you can too. If you found this video helpful, please subscribe to Legal Focus USA and turn on notifications so you never miss an important update. Share this video with anyone you know who is worried about their I-130 petition or confused about the new processing rules. And please leave your questions in the comments below. I read every comment, and your questions help me understand what topics I should cover next. Thank you for trusting Legal Focus USA as your source for clear, honest, fact-based immigration information. I'm Georgia, and I'll see you in the next video. Stay informed, stay calm, and remember that you are not alone in this process.